So we will try to look into. I'll try to discuss. I'll cover it from the what the changes we see from the old law to new law. So in that way, where the changes are, how these changes are will have its own impact on the administration of criminal justice. So we look into everything in regard to arrest. Now, arrest and rights of the accused persons. If you look at the CRPC, it is chapter 5 here also, where they talk about the arrest and the rights of the accused person. CRPC, it was section 41 to section 60A. In the BNSS, it is section 35 to 62. These are the broad provisions where the law laid down about the arrest. Now, let's see what the law is. As soon as we talk about the arrest, in the old law CRPC, two very important section was. So one section which was from the beginning of the CRPC, namely section 41, and then at much later stage, we added a series of sections to bring safeguard in arrest. Now, there's another backgrounds are there. The backgrounds are there. Impliedly, you can just uh, you must be knowing there's a in the national level we have a group body called Law Commission of India. Law Commission has come up with one of this report only on arrest, and in that report Law Commission said that 60% of arrests were unwarranted. That means the arrest not required, but police do arrest the accused person. So the 60% of arrest which should not have been taken place, but in reality, those arrests being made by the police department. So remember, every single arrest is resulted in deprivation of their right to life, right to protected under Article 21, and freedom under Article 19, liberty under 21. So because every arrest have some kinds of a violation of the constitutional right. So when we use legally, it should be used only when it is necessary, when it is required. So accordingly, the law tried to put safeguards, and the safeguards came in the form of section 41 capital A was added in the CRPC, where it says that the offences are divided into two categories, where the offences where punishment is up to 7 years. 41 capital A incorporated the new principle which says about notice. So before arrest, police should give notice when they think that the arrest is not necessary. There is a requirement of notice. So there is a very celebrated judgment of the Supreme Court we call Ernest Kumar judgment on 41 capital A, where the Ernest Kumar says that you have to give notice in every single cases. So it becomes some kind of a norm of issuing notice when they used to arrest under where the punishment is up to 7 years. Now, what the new law did in the BNSS, the both section of CRPC 41 and 41 capital A both clubbed together in section 35. So now we don't have 35, 35A. 35 is a basically merger of or compilation of clubbing of section 41 and 41 capital A CRPC. So it gives some advantage also, and I'll just explain what the advantage. Now, 35, the initial part, which is basically 41. So the 35 says this section has divided itself into offences in two major categories. One category where punishment is more than 7 years. Other categories where punishment is less than 7 years or up to 7 years. Now, when the punishment is up to 7 years, this B is talking about punishment is up to 7 years. So A is when When someone commit offense in presence of police officer, what the police will do? He should arrest. Now B is where the punishment is up to 7 years. What the police should do? Now B says that in cases where punishment is up to 7 years, police may arrest if the following conditions are satisfied. What are those conditions? Look, there are two conditions. So where the punishment is up to 7 years, two conditions. What is those two conditions? First condition is police officers own belief that that person has committed offense. That's the first condition. But that alone is not enough. It has to come with fulfillment of second condition. What is the second condition? So apart from the first condition, police officer is also satisfied that the arrest of accused is necessary. Why? Then you have A, B, C, D, E, the circumstances are there. What are those? A, to prevent him again committing offenses. Arrest is necessary for proper investigation. Second thing. Unless the arrest the person's, the evidence cannot be collected or he will destroy the evidences. Third conditions. Unless they arrest the persons, he will threat the witnesses. Fourth conditions. For the proper investigation, etc., arrest is necessary. Fifth condition. So there are 5 kinds of conditions are there. So that means where the punishment is up to 7 years, 2 requirement. 1, police officer believe that the accused has committed offense. 2, police officer believe that the arrest is necessary on any of these 5 grounds. And if these both the conditions answer is yes, police can arrest. So these lay down the conditions, and yes, they will write down those their reasonings why they think so, and thereafter they can proceed to arrest the accused persons. So this was where the punishment is up to 7 years. What about cases where punishment is more than 7 years? The cases where punishment is more than 7 years, you will find in clause C. What is the requirement? Here only one condition. Police officer believe that the accused has committed offense. That's good enough. So you can understand the difference. The cases where punishment is up to 7 years, 2 requirement. Police officer believe and the condition is such where arrest is necessary. Cases where punishment is more than 7 years, only one condition. Police officer believe that the person has committed offense, the police can arrest. And their other circumstances are remaining same. Now one thing, what the advantage comes here? The advantage comes is, what was section 41 capital A clause 1 has been incorporated in clause 3 of this 35, sorry. And this says, I'm reading the clause. Please have a look on it. The police officer shall, in all cases where arrest of a person is not necessary under subsection 1. What kind of offense was there in subsection 1? Both. Where punishment is less than 7 years or punishment is more than 7 years. That means that police has liberty whether to arrest or not to arrest in all offenses, irrespective of their punishment, it is less than 7 years or more than 7 years. Earlier, this notice provision was in the old law only where the punishment is up to 7 years. New law has incorporated this notice provision for all offenses. So where the police think that the arrest is not necessary under clause 1, police don't need to arrest. Police can issue notice. Now the law has incorporated a notice format also. This is the form which you find, form number 1 in the BNSS, in which they will issue the notice when police think that the arrest is not necessary. So whenever they think the arrest is not required, they can issue this notice. One more thing they have added, and I don't know what's the use, clause 7. And the clause 7 says, if someone is accused where punishment is up to 7 years, and that person is sick, infirm, old person, etc., then police cannot arrest without order of DSP. So this is safeguard, but these safeguards are there for only smaller offences where punishment is up to 3 years. Remember, most of the offences where punishment is up to 3 years, they are by and large bailable offences. Sometimes there could be non-bailable, but by and large there are many offences which are bailable when the punishment is less than 3 years. But in any case, this is the clause 7 has laid down this safeguard where someone is infirm, sick, aged, then they cannot arrest the persons where the punishment is up to 3 years without the permission of DSP. That's the safeguards. This was not there earlier in the old law. The first time they have incorporated this. Now, Arnis Kumar judgment, which I said, very celebrated judgment on the issue of 41A notice. But now, we got a new act laid on its own parameters. I said in last class also that in interpretation of statutes, you will find a principle that the legislature knows the law, legislature knows the judgment. So they are aware of the Arnis Kumar judgment, etc., and they laid down this principle. So whatever the principles applicable in section 35, that will apply. Thereafter, we all find the some kinds of protective mechanisms or protections for the accused persons, their betterment. So section 36 talk about procedure of arrest and duties of the police officers making arrest. So remember, when police arrest someone, there is the obligations under the law. They must be very clear of having accurate information, visible and clear identification of the person is arresting. Police has to prepare memorandum of arrest. Now, this memorandum of arrest issues, informing the relative issues, it's all from judicial interpretations. There's a case called Joginder Kumar judgment where Supreme Court has given a series of guidelines about the informing the family member, preparing the arrest memo, and on the basis of that only the CRPC was amended and they incorporated in the CRPC. Now the new law has added the same thing they have incorporated here also. The person with the family member has to attach that, or the friends, etc. Some minor wordings are being changed. Okay, one more change is there. It was there earlier 41C. So earlier provision was that every SP office or the commissioner office, there will be a, say, centrally they will maintain all the data of person arrested, control room, etc. New law expect that apart from control room, there will be a designated person at every police station. There will be a designated person at every district whose duty will be to maintain the data about all the arrests made in the police station and all the arrests made in the district. They have obligations to upload these informations on some portal, etc., to be developed. So when I take training, or I give training to the police officer, I normally suggest them that till the time we have developed those mechanisms where we can upload in the website, at least you should publish in the police stations how many people arrested yesterday. That notice has to be there by designated person. Right of the arrested persons to meet an advocate of his choice, 41D. It was there earlier, now become 38. But remember, you all are going to become advocate. So some advocate might say that my client has paid me huge money. I will sit along with him whole time in the police station. That is not permissible. And that's why earlier also, now also make it very clear that client has a right to meet with the advocate, but not throughout interrogation. So limited access. It's only to give advice and not to be a companion. So that's the law is very clear on that point. There are some cases also where court says about it. Can police arrest in non-cognizable offences? Now, we had a provision earlier in 42, which says the police cannot arrest in non-cognizable offences. The same thing has been incorporated in the new law. In the old law also, there's a one exception. The exception is when someone commit offences of non-cognizable offences in presence of a police officer. Then for ascertaining name and address, they can arrest. The same thing has been incorporated in the new law also, that if someone committed offences in presence of the police officers, etc., so for the purpose of ascertaining name and address, etc., they can be arrested. And as soon as the name and address is being ascertained, they should be released. So that's the what the provisions are. On arrest, we find one new provision, which are more in preventive in nature. But this provision is very powerful. In fact, when this new law came into existence, you must have seen in newspaper and other places also comments that this law is creating, making a police state. This law has given enormous power to the police. One of the reference point was once not 170. Once we do next section, I'll come to it. So 170, which is the replica of 151. This was earlier also in the CRPC. To prevent the commission of the offences, the police can arrest. 172, this is a new provision. That's what I was talking about. Now, very powerful provisions. Just or unjust, time will say. Use or misuse, time will say. But when people make comment that this law is going to convert it into a police state, one of the reference point was section 172, and accordingly, it became important that we must read these sections and we know what this new thing is. 172 clause 1 says, all persons shall be bound to conform to the lawful direction of a police officer given in fulfillment of any of his duties under this chapter. So if the police give any lawful direction, everyone has a duty bound to accept it. Tomorrow, some of the Sundarnath College students are doing demonstration outside the college. Some assistant commissioner came that I am executive magistrate. You disperse yourself. This is lawful directions. Student say, no, I will not go. Student will ignore. He says ignoring, disregarding, refusing. What will happen? See the law, what the law says. Law says a police officer may detain or remove any person resisting, refusing, ignoring, or disregarding to conform to the direction by him. Very powerful provision. So if the police has given any lawful directions, if anyone disobey, the persons can be detained and arrested. Now, this is very powerful provision. It was not there earlier. Someone may ask questions from you that earlier also police used to arrest. Now, that arrest earlier comes from other places. So, the earlier provision was that there might be some assembly who will become potentially unlawful and become unlawful. As soon as the assembly become unlawful, there is a power under, in the old law, it was section 129, were given the power to the police officer to disperse unlawful assembly, but not this kinds of power. The power which is given here to arrest, detain, etc. on disregarding. So one reference point was always there, 172, that this has given enormous power to the police officers to exercise this power, which may has a potential of misuse in some circumstances. Now, 40, earlier it was section 43. Private persons, can you arrest? Can I arrest? Answer is yes, law permit it. Earlier 43 it was there, now 40. When law permit? Law permit that if someone has committed any cognizable offences, non-bailable offences in presence of you, you can arrest. Old law has used the word, if you look at the CRPC 43, there the word was that after you arrest, you hand over the persons to the police. Police will do re-arrest. So what is specifically re-arrest? You will find in section 43 CRPC. Now the new law has avoided the word re-arrest. And they have laid down some timeline, 6 hours. So what the new law says, that when a private person is arresting someone, they should hand over them to the police within 6 hours times. And if the police thinks that reasonably he was arrested, then police take him into custody. That's the provision was says there. Arrest by magistrate under 44, they have a power. Earlier it was also 44, now become 41. Earlier they have a power, now also they have a power. Armed forces, there's a protections earlier, now also there's a protection. But where this protection applies? This protection applies when they do something in discharge of their official duty. So suppose if there's an allegation that armed forces, BSF, posted in the border area, after end of their duty, they were going from some village and they found some girl, they committed rape of the girl. Is there any protection? Answer is no. Law only protect, the idea of this protection is, they say armed forces is being used for controlling riot, controlling dispute. Might be they have fire, might be someone killed, might be they use force, injured. Now they need protection because they are discharging duty. But if they do some criminal activity which has nothing to do with their job, then there's no such provision apply. So 45 earlier, now 42, it gives protections to the armed forces when some protections, when they done something in their official duty work, they cannot be arrested. That was the protections there in the old law, and the new law that continues. How arrest can be made? Very important provisions. Earlier it was section 46. Now it is section 43. Very important sections and we need to look into. I'll just take a pause. Now, till now, what we have discussed, 35 till section 42. Anyone any questions till now? Anything which you have need clarifications, or which you read earlier, came prepared and you find something difficult or something you need clarity? Now 43, which was earlier 46, very important section. What does arrest means? Arrest means taking someone into custody. But if that someone agree to give custody even by expression of word, so say police came to me and say, Mr. Khan, you are under arrest. I say, okay, I'll go with you. Does police need to touch my body? Does police need to handcuff me? Answer is no. Law is very clear that there is no requirement of use any kinds of force for the purpose of arrest unless it is necessitates, unless it becomes necessary in the given circumstances. As a general rule, there is no requirement of any kinds of use of force for the purpose of arrest. And accordingly, this is the most significant sections to understand, because many times when we see brutality of the police force. We see nowadays many places police beat the accused, parade them on the road. It is not permissible under the law. Law has not given any permission. It is completely illegal. In fact, if someone do some illegal thing, other party has right to private defense. If I am being illegally tortured, I can exercise my right to private defense and beat. So in my view, if someone's police is doing illegal activities, other persons have right to exercise their right to private defense. Not only that, other persons right to private defense. If you look at the IPC, now the Nyaya Sanhita, right to private defense can be extended to the property, can be extended to the body, not only by that person, also by the other person. So the law is very clear. You should use minimum force for the purpose of exercising this right. So what the law says, 43, I'm just reading it. In making an arrest, the police officer or other persons making the same shall actually touch or confine the body of the persons to be arrested, unless there be a submission to the custody by word or action. So if there is a submission to custody by word and actions, there is no need of touching the body or confining the persons. Then there's a proviso. It was there earlier also. Provided that where a woman is to be arrested, unless circumstances indicate to the contrary, her submissions to the custody on an oral intimations of the arrest shall be presumed, and unless the circumstances otherwise require, or unless the police officer is a female, the police officer shall not touch the persons of the women for making her arrest. Law is very clear. A female cannot be touched by male. A female is required to arrest them. There's a presumption that the women are agreeable to go give the persons into custody. And now if they're required to arrest, touch the person, then it should be female. Then the issues comes, what if the persons resist arrest? Then the law says you can use force. How much force? As much as reasonable. So if the persons resist force, etc., evade force, the police officers can use necessary force for the purpose of executing arrest. That is permissible under the law. Now we know there's a Supreme Court, many cases where Supreme Court says handcuffing is illegal, not permissible. Now in the new law, we have reintroduced handcuffing. So under 43 clause 3, we reintroduce in specific categories of cases, but those specific categories are also very broad enough. So you will find all these in clause 3, these kinds of offenses where police may use handcuffing to the accused person's law permitted. Clause 4, it was earlier in clause 3, which says nothing in this section gives right to a cause to a death who is the accused person of the offense punishable with death or imprisonment for life. So what is the other reading will be? Other side reading will be that, okay, if the accused where the punishment is life or death penalty, then for arrest they can cause death. Answer is no. Then the issues come proportionality. Was there that much danger available? So yes, to execute arrest, law says you in no circumstances you can cause death unless the person is accused of where the punishment is death or life imprisonment. But then even if the person is accused of life imprisonment or death penalty, it should be your force or police person force should be proportionate to the danger caused, not the manner in which we see many encounters taking place. Those encounters are nothing but pure murder. The police officer who do those encounters, they are murderer and they should be prosecuted as murderer, because in the society which is governed by the rule of law, there is no law permit to do these kinds of encounter uh, when which was not proportionate enough, where there was no danger was posed there. So the kinds of a murder being carried out in the name of the person is running away, it's the planned kinds of murder, and we have seen in many places this report has surfaces the manner in which being carried out. Law does not permit. So for clause 4, when they permit, there's an additional requirement of proportionality, where the apprehension or the fear was posed proportionate, that danger was there proportionately or not. Now this provision remains same what was there earlier. In my view, they should have made changes here, but they have not made any changes. So law remains same for arrest of a woman from sunset to sunrise. They cannot be arrested unless there is a permission, prior permission obtained by a magistrate, impliedly judicial magistrate. Now I said, why I said I have to change it requirement. Now almost every single group, you name the terrorist group, you name the arms group, you name the organized crimes group. Uh, there are female companions for those crimes. If the necessity arises, why not to arrest? Uh, do we believe that police don't arrest them? Only thing they do arrest them in the night might be, and then showing them in the morning arrest. So the arrest might be shown in the morning. Police has to do something at the time when they have to take action. Now, what the changes they could have done? I'm not against the complete protection. There should be protection. They could have changed this from the magistrate or judicial magistrate prior permission. They should have make it to executive magistrate. So, save in exceptional circumstances, no women shall be arrested after sunset or sunrise. And where such exceptional circumstances exist, the women police officer shall, by making a written or obtain the prior permission of a magistrate of first class, that means judicial magistrate. Remember, we don't have any mechanism for getting information by the judicial magistrate in the night. Where is the infrastructure? Where the judicial magistrate available in the night? So this, instead of judicial magistrate, they could have put provisions for the executive magistrate with condition that only women can be kept them. They can keep only in the women custody with sufficient safeguard. So those kinds of things have been incorporated instead of this blanket, some kinds of a denial of right to the accused. Someone say, okay, now permission is there, but permission, we don't have an infrastructure to implement these permissions. So that's provisions for the arrest under the section 43, which was earlier 46. Now again, very important sections. 40, earlier it was 47, it is 44 now. What if, say, the person who is going to be arrested, he run away and enter someone's home? What the police should do? So 44, earlier it was 47, they given power to the police to go to that home, knock them, ask them to give the police access. If the law also says, this section, that it is a Pardanishi women, etc., in the home, then giving them some time, though they can keep themselves inside, and police can go to premises and do the arrest, search and arrest. But if it is not possible, then this section says that police can use all means necessary, including they can break the door, they can break the window, they can use force. So ample power has been given to the police officers to exercise this power to arrest under this section. So it was there earlier also. The same thing has been incorporated in the new law, no changes. Where they can arrest? They can arrest throughout the country at any place. There is no bar. Unlimited power given to the police officers to arrest throughout the country, any places. Earlier 49, now 46. Safeguard. The persons arrested shall not be subjected to more restraint than necessary to prevent his escape. That means we should not use more power to detain the person. Police should not use more power to detain the persons. Remember, there was a case case name is Delhi, probably Delhi Bar Associations versus state or something, where a magistrate was paraded. Supreme Court directed that no, cannot do that. So now they laid down the guidelines that without order of the district judge, etc., session judge, you cannot arrest. So law says no unnecessary restraint. What we see, police use exorbitant force. Police use lathi. Police use their power on the helpless people who are being arrested. 47, very important right. Persons arrested to be informed of the ground of arrest and right to bail. So in bailable offences, every accused person has right to be enlarged on bail. Anyone who is arrested must be informed about the ground on which the person is being arrested. What were the allegations? They have to inform. This is their rights. 48, it was 50A earlier. Obligation of the person making arrest to inform about the arrest, etc., to relative or friend. Earlier, it was a nominated person. So when a police arrests someone, it is an obligation. Then they should inform the family member of this being arrested. One more thing is there. They have to inform the designated person of the district. If the accused persons belong to some other district, they should inform the other districts also. So earlier the word was nominated persons. Now it says relative or friend. Search of the arrested persons, 51 earlier, now become 49. Now this power was earlier also. When a person being arrested, he can be searched. Once they search under this section, the next section said that anything which found contraband materials, etc., they can be seized, or weapon, they can be seized. Now, when we discuss about search and seizure, we'll discuss this also. Now, in search and seizure, there is a section called 105 has been added in BNSS, which mandate that in every search and seizure there should be audio, videography, etc. If that is carried out within that chapter, but this section is completely in the different chapters. Accordingly, that provision is not applicable. Uh, so I normally say sometimes that now it may completely foolproof. Suppose police is coming to X person's home, there's a audio, video recording, etc. So chances of plantation is not there. But say police arrested Mr. X and then plant something in their body and then so seizure under 50, this 50, there's no audio, video recording means. So still, this section has left a chance for planting of materials on the accused. Now, medical examination of the accused. After the DK Basu case, medical examination of the accused are mandatory. Every accused person before producing in the court are being medical examined in the court. So there are many sections. It was earlier 53, 53A, 54. Now also we have 51, 52, 53. These sections are there for medical examinations. What's the new thing has been added for medical examination is that now they impose an obligations that the doctor, when they will do the medical examinations, they have an obligations to inform about their report. They should send the report to the police officer without any delay. That's the word is being used. They may call again for medical examination, that also permissible. Now they use the word any police officer. Earlier it was used the word not below the rank of sub-inspector. So the new thing which they have added is the registered medical practitioner shall, without any delay, forward the examinations report to investigating officer. This was not there earlier. So this is the new inclusion in this law. So registered medical practitioner has to give a report without any delay. In Anil Anantrao case, the importance of the expression examination of the persons cannot be confined only to external examination of the body of the person. There can be any kind of medical examination which require. Now, for the rape accused, a specific section was added earlier in section 53A in CRPC. That 53A become 52. And when this was added, when 53A was added, parallelly one more section was added for victim under section 164A CRPC. Now, so this section is about specifically on the rape accused case, their medical examination. And what the significant change here is, the law says that if the government hospital is not available within 16-kilometer radius, the medical examination of the rape accused can also be, preliminary medical examination of the rape accused can also be conducted by any registered medical practitioner. Very progressive provisions. The reason being that you might get some kinds of a mark, something, some sample which can use for DNA checkup, which require immediate medical examinations. So this law permit that to preserving that for immediate medical examinations, etc. They can do immediately, because many times from in that cases, this medical examination provision which is there under the law, It was a significant improvement that point of time, and again the same thing has been carried forward in the new law. So we don't find any changes. Whatever is there, from there the DNA test or other profiling can be conducted. That's what the law had says. Now 70, it's 53, which was earlier 54. Examination of arrested person by medical officer. Now here, one very significant improvement is you see this proviso. So if, earlier what happened was once the medical examination is done by the doctor, some medical examination might not be possible in one day and they need again to bring them. Now the law make it very clear that the registered medical practitioners thinks that one more examination of such person is necessary, he may do so. So he may direct for bringing them. So it's a good provision which they have added, with the same kind of a safeguard that they have to send the report without any delay to the police officer. That's what this says. After arrest, one more process which conducted earlier, we call it TI period, test identification period. Now in CRPC for long time, there was no provision for TI period. It was added much later stage at section 54A. The same thing has been incorporated under 54. So TI parade or TIP can be conducted by the in the jail premises or other places, and the statement can be recorded of the accused. A very important piece of evidence says now TI parade being conducted at the earlier stage, and the victims or other identify the accused, it gives some kind of a sanctity or surety that the right persons are being arrested. So that's give advantage of it. In some cases, when TI parade is conducted of a person who is some kinds of disability or some other persons like so physical or disabled, etc., then the law says for their TI parade, it should be conducted by audio, video, electronic means. That means the entire process need to be videographed. So again, it's a very progressive provision which has been added in the BNSS. It's not very serious. It's basically just a procedure when police officer deputes subordinate to arrest without warrant. So basically, it's directions, identification which need to be communicated to subordinate. So it's the police officer's role. Not we are not concerned. Then the other safeguard, like 55A, it was earlier health and safety of the arrested person, that become 56. So the custodians, the police are the custodian. In this custody, the persons are there. It is their responsibility to ensure the health and safety of the accused person. So it says it shall be the duty of the persons having the custody of an accused to take reasonable care of the health and safety of the accused persons. 7, which was earlier 56, person arrested to be taken before magistrate or officer in charge of a police stations. So we know there is a mandatory requirement of producing someone to the court within 44 hours. Here it says when a person is arrested, they have to take to the magistrate without any delay or to the police officers. The next section laid down the mandate. Now this is the mandate comes from the Constitution. So Constitution mandate that the arrested persons need to be produced before 24 hours. Now there is a very important change here. The last line, if you see in the red color which I marked, this is new thing. You might have seen in sometimes that one state police reaches to other state. Other state police says, no, I will not allow to arrest here. Sometime a police officer taken some persons to the magistrate. Magistrate said, no, you are from the other jurisdiction, I will not accept the accused. Now the law 58, the last line is very clear. It says that when police arrest someone, brought to before the magistrate, whether the magistrate has a jurisdiction or not, they have to pass appropriate order. So what the appropriate provisions available? Magistrate can either continue give custody, transit remand, or magistrate can release on bail and asking them for to appear in the appropriate court. But they can't say I will not accept the accused. So that's now explicitly we have a provisions where it says having jurisdictions or not. So that's a very few words added, but it's a very powerful provisions because we have seen those kinds of disturbances in few cases. 59, police has to report apprehension. Now it was earlier also, but police never bother about it. I don't think any places or maybe in few places they are complying with. The law says that whatever the arrest being conducted, they have to inform to SDM, etc. Many places I don't think it's comply. Discharge of the person is apprehended. If the person is apprehended and there is nothing is found, so no person who has been discharged by a police officer shall be discharged except on his bond. Now, this is the section which we see when police arrest someone, even if there's nothing against him, when police release them, they take a bond from them that as and when they will be asked for, they will come. This come from this section only because once a person arrested, he cannot be released without on taking bond. Bond can be personal bond, bond can be bail bond, third person surety, it can be personal bond. Then only persons can be released. Earlier it was 60, now becomes 61. Power on escape to pursue and retake. So anyone who escaped, they can be again arrested, brought back. That's the power was there earlier also. Again, the same power is there. So custody, escape or rescued may immediately pursue and arrest him in any place in India, where they can pursue any place in India throughout the country. Again, arrest to be made strictly in accordance with Sanhita. So what the BNSS says, the power which has been given, they have to use that power to execute the arrest. So a very wide power which are there under the law. So the kinds of power which they have given, that power need to be exercised to execute the arrest. I said that many safeguard what we look at today in the BNSS, earlier in CRPC, the root is in the Constitution, Article 22. So Article 22 laid down these basic rights. One, accused must be informed the ground of arrest. Two, right to consent and to be defended by a legal practitioner of his choice. Three, right to be produced before magistrate within 24 hours, the rights of the accused. Four, right not to be detained beyond 24 hours except the order of the magistrate. These are the rights which law recognizes. Two cases which I have given here. One of the major significant changes in the CRPC was made. They were on compliance with Joginder Kumar versus State of UP. In the Joginder Kumar, first time the court laid down those requirement of arrest memo. You must have seen now that in many places, when a person being arrested, they prepared an arrest memo, hand over the one of the copy to the family member. They inform the family the person being arrested. They have to write the compliance. Many time in practice, there might be some uh, tea shop outside the police station. He's writing all as a relatives. That's practice that might happen. But on theoretical part is a very important provisions, very important safeguard, because many time a person being arrested, the family members are not informed. Law says you must inform them. They have right to know that if the person has to be informed where the accused being taken next day to the which custody, etc. So Joginder Kumar versus State of UP is a landmark judgment in respect of creating the rights of the arrested persons, right to know about the things, arrest memo, informing the family members, etc. All these come from the Joginder Kumar judgment. Very important judgment. DK Basu case. We all know it's all started from the West Bengal. And this is the case which created a system where for every single accused person being arrested, they are being medical examined and thereafter they produce in the court. Court has to see whether it's complied with or not. So these are the safeguards. So this judgment has played very important role in shaping the rights of the accused persons. Arrest is one of the most serious consequences it has on the right to life and liberty of individual persons. And accordingly, law consistently laid down the safeguards. It talk about minimum use of force under 41 A, which was there now 35 clause 3. Police can, in any cases, whether it's a serious, non-serious, whether the punishment is less than 7 years or more than 7 years, if the police think that arrest is not necessary, they don't require to arrest, they don't need to arrest. Arrest is a complete prerogative of the police department. Police will decide whether to arrest or not. Why so? The reason being, what is investigation? We have seen definition yesterday. Investigation means all process conducted for the purpose of collection of evidence. There might be a case where from one accused, police may collect more evidence without arresting them. But there might be a case where police can collect evidence after arresting them. Rape cases, they have to do medical examination of the accused. So they need to arrest. So this is the prerogative of the police department. They will decide whom to arrest or not to arrest, because the primary role of police is to collection of evidences. And with that ultimate objectives, they use that mechanisms for arrest and using the force. So that's basically the provision which was there for the arrest. Uh, what we discuss today.